This session is going to be a little on the drier side.
No.
Not all of district court litigation is mega exciting.
You have to understand the rules, the mechanisms, the deadlines.
Yes. So this session is going to be dry and a little boring, but this is going to get you through the scary stuff that you really need to know in order to not get in trouble when you're doing this. All right? So, of course, we're talking about the Federal Rules of Civil Procedure.
First year law school.
Right. So first, actually, before we do FRCP, let's talk about the different types of rules that you need to follow. Of course, there's statutes, regulations. Federal Rules of Civil Procedure create the general framework for civil litigation. You have to know them. If you have some notes from your civil procedure class in law school, you really want to dust those off. That's going to be really helpful to you.
From 25 years ago?
Yeah. In fact, I had a good civil procedure professor and paid attention, and that gave me a great groundwork to start litigating.
Buy a Horn book. Go order one online. Get yourself Civil Procedure for Dummies.
Yeah.
And actually getting a copy of the Civil Procedure rules annotated is not a bad idea, because then when you start getting into the motion practice, the AUSAs and the DOJ lawyers are super general practitioners of the federal system. Yeah. They know the rules and they know the procedures better than we ever will. And assuming you're an immigration lawyer, we know the immigration law better than they'll ever know. So we have a substantive advantage and they have a procedural advantage.
Right. Apart from the FRCP, every court has local rules for that district. And so you really need to know those. Sometimes they will modify the FRCP with things like timing requirements, deadlines, page numbers, formats for pleadings, things like that. So you have to know the local rules. You have to refer back to them often, all right? There's also standing orders that might be specific to a district or a courthouse. And then often individual judges will have their own standing orders or practice rules. So sometimes when you're doing a case, there's like 4 sets of rules that you have to keep in mind.
Yeah, what I do is I have 3 screens, as Mark saw earlier today. I'll open up on one side, and I'll just open a Word document, and I'll write down notes and say to them, okay, well, FRCP says this, local rule says that, and then Judge Smith's practice procedures says the third. Right. That's going to control. Right. So, and you actually might have an order issued in your case. Right. But if not, if the judge has a standing or a generic order on their website, you're better off following what and sometimes it's more generous. Sometimes they'll give you 21 days to respond to summary judgment, but only 14 days for motion to dismiss.
Right. There are also sometimes other types of rules specific to a district. Like sometimes there's electronic filing policies that actually can have a big impact on your case. They say what you can file electronically, what has to be done on paper.
In Vermont, they want you to file your exhibits individually.
Yeah.
And in Chicago, until recently, you had to email your request for summons. You couldn't file it. Sometimes the judges want you to file an order. Sometimes they only want you to email the order. Yes. DC, they want you to file the order and never email the order.
Right. This is a big thing, how to file certain things. Like generally everything you file online on the CM-ECF platform. Sometimes you have to email in a draft order. Sometimes you have to file something on paper. Like let's say perhaps it's under seal or something. Mm-hmm.
Eastern District of New York, you don't file motions and briefs. You serve them the other side, and then at the end you compile everything as a binding rule. Wow. And the last person to write something, they actually file the binded copy with the judge. And then you got to give the judge actually like a binder, a real physical binder with all the documents. So chambers copies, chambers copies.
Chambers copies are such a pain. So in a lot of places, there's like a default rule saying anything you file, or if anything you file over like 50 pages, you have to mail a physical copy to the judge. A lot of judges don't want that, so there might be like a standing order.
Pre-COVID, it was like, we want a copy of everything. Yeah. And then during COVID, it's like, we don't want you to mail us anything. We don't want to touch your cooties. Right. And now it's judge by judge. Right. But yeah, definitely, and you have to know, how do you tab it? No blue backing. That is something from the old days. Right. But certainly tabbing on the right, 3-ring binder, hole punch. Yeah. The judges will get very specific, and you can never go wrong by reading what is on the judge's website. If you have to, you can email the clerk's office, but you want to CC opposing counsel, which might get a little embarrassing.
Right. So there's a lot of rules you got to worry about. If you are not aware of a rule or you break a rule inadvertently, you'll probably find out because the clerk will reject your pleading, or you'll see a notice on the docket saying for you to refile
Quality
something.
control messages.
Listen, don't get hung up on that. It happens to all of us. Like, you want to minimize that, but don't feel bad if that happens to you.
Just don't make the same mistake 3-4 times.
Right. All these sets of rules, you can familiarize yourself with them usually just by looking at the court website. Like, they'll have the FRCP, local rules, standing orders, judges' rules. So anything you have to worry about is usually going to be on the court website. So if you're new at this, just spend an hour or two on the court website before you file.
One important thing I think is that don't rely only on your staff to be able to do the filings, because they're using your ECF password and ID, and anything they do wrong is in your name. So if you're the kind of, I mean, I've had local counsel literally where they say to me, I can't file today, my paralegal is not at work today. If you don't understand what your staff is expected to do, you can't manage them.
Right.
You cannot delegate the ethical responsibility to your staff. You can delegate assignments, but actually the core ECF rules and procedures expect that you as a lawyer are doing the filings and that you're not sharing your password with other platforms. And there's a lot of security involved, but you need to be able to understand how to do the filings and do them correctly.
Right. Especially if you're writing up until midnight and the staff has gone home.
Yeah, and as you said in one of our earlier sessions, the courts have really good pro se guides and then good ECF user manuals. So every different court's going to have those, and they may actually have step-by-step screen captures of how to do something correctly.
Right.
Some courts, like the Middle District of Pennsylvania, you have to use a dummy case number.
Right.
If you don't know how to find that, you can't file the case, and you're banging your head off the monitor because there's some magic formula number you got to put in there. It's in the ECF guide.
Right.
It's in there for you, but you're not taking the time to read what you need to before you do it.
Yep.
And lawyers, we love to just assume we know it and do it. Federal court, it's kind of complicated.
It is. You would think that since this is a federal system, there could be more standardization. However, there is a lot of variation.
There's either 92 or 94 district courts, and they all do things their own way.
Yeah. And I guess to a certain extent, it's, diversity can give strength to a system. However, if you're like us, you're practicing in multiple jurisdictions, it can be really hard to keep track of all this stuff. However, we are going to go through some of the
FRC doesn't change. The FRCP is standard.
We're going to go through some of the most important rules from the FRCP that you have to know. Again, this is boring, but this is going to be easier than you having to repeat a filing because your filing got rejected. All right?
Or you miss a filing.
Yes.
And then you have to ask for leave of court to get the filing in.
Right. All right. Rule 4I is how you serve process on the United States. Just to summarize, you have to serve the U.S. Attorney's Office, you have to serve the Attorney General, and you have to serve the agency or the officer that you sued.
But what's the difference between the first and the second?
Right. So the U.S. Attorney is going to be the local DOJ staff member that is probably going to represent the government in your case. So you have to serve their office. Now, you can either deliver a copy to them or you can mail it by a certified or registered mail.
So there's 92 or 94 U.S. attorneys in the country.
Right.
Every single district has one. The U.S. Attorney General, actually, I hate that. The Attorney General of the United States, there's only one. That person's in Washington, D.C., and they lead the U.S. Department of Justice. I got called on a case. The client was like, we didn't get a response. We served them. It's been 90 days. That person served the U.S. Attorney in D.C. The lawsuit was filed in Connecticut.
Yep.
They served, and that person doesn't understand. In fact, I think they may even serve the Attorney General.
Right.
And not any U.S. attorney at all.
Right. I am convinced that those service pleadings on the Attorney General go into like an incinerator in the basement of Main Justice because it doesn't seem to serve any purpose whatsoever.
They've admitted that they X-ray everything and some of it gets destroyed.
Yeah. And same for the agency pleading, also doesn't seem to be too important. The service that most matters is the one on the U.S. Attorney's Office. That is the one that sets the government's answer deadline. So whenever a service is complete as to the U.S. Attorney, then they get 60 days to respond for most types of lawsuits.
You'll occasionally get a judge that will be an outlier and say that service starts on the day the last summons was delivered.
Right. Well,
that's weird.
I believe there's one of the FRCPs that says service on the U.S. Attorney is the date.
That's the classic.
But you do have to serve all three for service to be complete. So if you just serve U.S. Attorney and then you delay the other two, the deadline is not going to...
Right. And a really astute DOJ lawyer will find out if you've done service correctly. If you haven't, they will write back saying, we are not acknowledging service. You did not do it correctly. Right. You used FedEx, can't do that. You used UPS, can't do that. I personally will serve, funny to say personally, my practice is to serve the U.S. Attorney by hand delivery, and because then I get an affidavit from someone other than me. I mean, in Denver, I'll do service myself, but anywhere else, I hire a process server, I get an affidavit, I file that immediately, and at the same time, I'm doing certified mail on the Attorney General in D.C. and on the defendants. I very rarely have to file proof of service for them. Usually, once I file proof of service for the U.S. Attorney, they will enter their appearance sooner or later, and at that point, any objection to service is waived.
Right. Let's move on, because we have another session where we'll talk about service, I think. Rule 5.2a, you have to redact certain private information from pleadings. You're not allowed to say a whole social security number. You're only allowed to say the last 4 digits. If there's a date of birth in your pleading, you can't say the whole thing, only the year. If there's a minor's name in one of your pleadings, you cannot say that. You can only say their initials. And then lastly, if there's a financial account number in one of your pleadings, you can only list the last 4 digits. So you may have to redact things from your pleadings. Sometimes people will file like USCIS receipt notices. Those might have dates of birth. Be careful with that stuff.
I also take out the place of birth. These are the personally identifying information, the PII. So I'll take out the city and just leave in the nation or the state or province. And the other thing that I will take out, some people are sensitive about alien numbers. I leave them in.
I don't, because if you get a decision in a circuit court case, the A number is public.
I've done it once where I took them out, and the DOJ lawyer said I need those to get any action on the case. So I put those in my caption as either the alien number or the service receipt number or both. And then I think that was all the redactions. Yeah. Some people will say that if you use code 465, that
that's the next rule.
Okay.
So rule 5.2c is about restricted access to immigration and social security cases. So if you sue the government and you list your case, you classify it on your civil cover sheet as an immigration case, then the public will not be able to access the pleadings online through PACER. The only people who can access the pleadings are the counsel of record. Also, orders by the court will be publicly accessible, right?
And decisions.
Right, and anyone can go to the local courthouse, to the public terminal, and access the pleadings. So there's a certain measure of privacy, but if there's like a journalist interested in your case, they can get everything. They just have to drive out or send someone out to get it.
And if you don't follow this rule, or the prior rule, and you include minors' names, if you include dates of birth, and someone gets a copy of it, it's malpractice, right? I mean, you're revealing information that you're not supposed to under the rules, and then you might get an error from the judge or the clerk's office, and you may have to refile something as an errata.
In my experience, they don't enforce it. They rely on us to make sure that we're doing it. If you goof up, which I have, you can file a motion to amend it, and then they will substitute out the old version and replace it with the new one. They'll do that for you.
And sometimes if I as a default, I use code 465 for almost all my lawsuits.
Yep.
But if there is a case where you're challenging a policy of the government, the U.S. Attorney's Office may come back and say, we want this to be unsealed. Right. And then you have to basically argue to the judge whether or not the 465 is really appropriate or not, because there's a default assumption that court cases are public.
Yeah. But also, there's not much definition to what is an immigration case. The FRCP 5.2, it just says immigration cases. So whatever.
I think it covers naturalization cases. I think it covers cases involving green cards and visas and adjustment of status.
Yeah.
But you're right. I mean, it's immigration's a broad. I've dealt with CBP cases. I don't know if they were immigration. They're border control.
Yeah. When I've done cases that are kind of like impact litigation or of public interest, I've also had that experience where the U.S. Attorney tries to get it opened up, and then there's this little back and forth with the
I think
clerk.
the judges like to err on the side of things being public.
Yeah, right. All right, Rule 12. This is a huge one. Rule 12A identifies the time frame for the government to answer a pleading. So it's 60 days from when they get service.
Your clients may think it's 30 days, but because you're suing the U.S. government agency or an officer, it's 60 days.
Right. So the reason for that,
and for appeals too.
Yeah, the reason for that, it sounds unfair. However, the drafters of the federal rules knew that the government is large and bureaucratic. They need an additional month to get their act together and figure out how to respond to a lawsuit. So that's just part of the FRCP.
It's more time for you to get your case resolved.
Yeah. Rule 12B is about defenses and how they are asserted. Rule 12B1 is really important. That is about motions to dismiss for lack of jurisdiction, right, on jurisdictional reasons. And then 12B6 is motions to dismiss for failure to state a claim. So that's where the government accepts jurisdiction. They basically are accepting the facts as you stated them, but they think that still, despite all that you've said, you still don't deserve relief from the court.
Yeah, the way I phrase it is that 12b-6 says, assuming everything you said is true, you have not sufficiently laid out a case that the judge can give you a judgment from.
Yeah,
there's something so wrong in your complaint, something is missing.
Yeah.
It's almost like a directed verdict.
I think it's 12b-6 motion says, so what?
Right.
Yeah.
And 12b-1 is like, Judge, you shouldn't even hear this case in the first place.
Yeah. Rule 15a tells you when you may amend your pleading. And this is
it's critical, yeah.
This is a tactic you really need to keep in mind. You can amend your pleading as of right, meaning you're entitled to do it within 21 days of serving it. Or if it's a pleading that requires a responsive pleading, then you can amend within 21 days of that responsive pleading. So let's say you file a complaint, government files a motion to dismiss. You want to change your complaint, add more detail, try to address some of their objections. You're entitled to file a brand new complaint. You don't need a motion if you do it within 21 days. Now, in every other case, you can amend your pleading with the permission of the court, and the court is supposed to give that pretty freely and liberally.
And pretty much almost all the cases we work on in the immigration context are going to be a pleading where a response is required.
Right.
So you're going to have those time frames. What's embarrassing is if you don't understand the rule and you ask for leave, or if you ask the opposing counsel for their position when you don't have to, you're showing the fact you don't understand how the FRCP rules work.
Right. A couple of things about this. Let's say you're expecting to get a settlement, but you don't. You get a motion to dismiss. You now have to have some additional conversations with your client, especially financial conversations. What's the payoff for this lawsuit? Are you going to invest in this? If you need to get some time and there's some things in your complaint that you want to do a little bit better, you file an amended complaint. You've now mooted their motion to dismiss. They have to file a new motion to dismiss.
It's awesome. It's a great.
Yes.
It's not a tactic. It's a great benefit.
Right.
And one thing I'll say is, and if, this is not from the big law firm perspective where you bill by the hour, but as a solo that does flat fees, I include motion to dismiss in my initial flat fee because I never ever want to be the lawyer that gets a motion to dismiss and then withdraws the lawsuit. I think that's Bush League and cowardly. I'd rather lose a motion to dismiss once in a while versus be the lawyer who's scared of motion practice. So I think my credibility is better when I will actually do the motion practice, write my brief, and argue to the judge. You're not going to win every single case. Litigation does not work that way. Immigration, we're used to, I have 90% approval or 97% approval. Federal court, you hit 50%, you're doing really good. It's a contested adversarial system, right. So you're going to win and lose. It's how you do it is going to maintain or hurt your credibility.
Yeah. All right. Rule 16 is about pretrial conferences. Often there's a lot of, discussions with the other side before something gets litigated.
I think these are great. Rule 16 and the corollary Rule 26, they are tools that the courts use to manage the docket, and they put affirmative requirements on the parties, but in reality, you're talking about the lawyers. So if there are required disclosures under either of the rules, you are supposed to meet and confer with your opposing counsel. You're supposed to show the cards in your hand. This is my witness list. These are my claims. You're supposed to trade all this information, and the judge is going to make you file a joint Rule 16 or a joint Rule 26 filing, and the judge wants you to lay out everything in the case. They want you to narrow the issues to what's really contested, and they might even ask you to go ahead and put up some briefing schedule deadlines. That's wonderful because they don't know your calendar. The judge does not know that you're going on vacation in July. So why not have the lawyers figure out everything possible first and then have the judge only deal with the issues that are left over? I think Rule 16 is more of an earlier situation. It could be before Rule 12 is decided. Rule 26 I see more often after a motion to dismiss is denied. Then the judge says, okay, in July 30th, we're doing a Rule 26 conference. You need to contact each other, file something 10 days before the conference. And that's what the judges expect us to be big lawyers and pull on our pants and actually do what the rules expect us to do. And the judges, their own their web pages may have guidance on they may even have a form they want you to use for the joint statement.
Right. Litigation, you're actively managing the litigation with the other side. Usually anything that you want to take to court, usually you have to take it to the other side first. Yeah. So you're always coordinating with the U.S. Attorney's Office. You do need to make friends with them. Most of them are very nice and want to do the right thing.
And some of the rules require meet and confer on non-dispositive motions. Yep. So if you're filing a motion to dismiss or a motion for summary judgment, you may not have to get the other party's position on it, but if the rules don't talk about it, the judge's procedures might talk about it. You're never going to go wrong by talking to the other lawyer about a motion and just saying, hey, I'm going to file this. What's your position? They might have a way of resolving it, and that's what the courts expect us to do.
Right.
When you miss a conferral, that's when you get in trouble.
Yeah, you don't want to do that. Rule 56, summary judgment. So this lays out some of the standards for summary judgment. Summary judgment is how most APA claims get resolved if they don't get settled or dismissed.
Yeah.
So,
and Rule 56D is summary judgment discovery.
Yes.
So you may be able to get limited discovery to deal with issues on summary judgment, and you need to definitely look. Rule 56 is fairly brief for the amount of work and the amount of decisions that come under it. The local rules, you may see Rule 56.1 in your local rules. That's where the courts really hash out the details of the procedure, and you may have to file supplemental filings that you never heard of before and never had used in your local court. You might actually have to. I've had courts where they make the DOJ and the private lawyer file one statement of facts they agree on. And then if you really want to push the judge, you file your own list of facts that are still in contention. So there's a lot of details between the local Rule 56.1 and the judge's court procedures. They're going to really specify how they want, even down to how many briefs are allowed. Do you get a reply brief? Yeah. No, sir, reply briefs are allowed. What the order of briefing is going to be done. Some judges have very specific requirements. Other judges will go with defaults. But you need to compare the federal rule, the local rule, and the local practice within the judge or the judge's standing order to really figure out. And that's what you want to put in your Rule 26 statement. You need to actually map out all of those deadlines and details.
Right. Now, a little bit about local rules. Let's talk about the things that are most likely to be changed by local rule. One big thing is, how are hearings scheduled? Every place seems to have a different system for scheduling oral argument, right?
California is horrible. Yeah. The judges they're horrible for non-California lawyers to deal with. I like California. But they will literally say, you have to look at the judge's calendar. Mm-hmm. The judge will have certain days for motion hearings. You have to notice the hearing at least 5 weeks before the deadline on an open date. And then the judge's calendar will have X's where dates are already full. Mm. So you might be looking at 2 or 3 months away for a hearing date, and then the judges will cancel the hearing and issue an order on the papers.
Right. Virginia, whenever you file a motion, you have to either set it for a hearing at the same time, or you have to file a waiver of your hearing. Another common situation is DC. You just file your motion, and then the judge has the discretion. If they want a hearing, they will let you know.
One thing I will say is that a lot of the courts will say if you don't ask for oral argument, it's waived. Mm-hmm. So you may want to ask for oral argument in your complaint. You definitely want to ask for oral argument in your motion or in the brief. And you want to look at the local rule and see how it's required. It may be that you have to have it in the caption on page 1 and not buried in the body of your motion, the body of your brief. So a lot of courts are looking now with the number of cases to not have oral argument. Yeah. And it's always in the court's discretion whether they're going to give you oral argument. If it's a 1447B case and you're going to have a de novo hearing, you're going to have a hearing. If it's a habeas, you're probably going to have a hearing. Motion practice, a lot of the courts are going to try to rule efficiently. They may not give you oral argument.
Right. Some other things that are often varied by local rule is page limits on how many pages you can put in your brief.
Or word count. Now some places are going by word count.
Word count. A lot of jurisdictions require certain things on the title page of your pleadings. A lot of districts in California, the title page looks completely different from a lot of other places. Every line needs to be numbered.
That's the whole document.
Yeah.
And on the caption on page 1, you have to have your name, your law firm, your telephone number, your email address.
First 9 lines have to have all this info.
Pro se pro.
Yeah, you need title, case number in the right spot, name of pleading in the right spot, and then you go down from there. Let's see.
They will only give you one summons.
Yes.
Whereas
there's a lot of variation. All right. The summons form, there is a standard nationwide summons. So you would think that the practices as to summons would be uniform. There's great variation. And often the way a court does something is not stated anywhere on the court website. You just have to try and see what the clerk says. The clerks are not supposed to be rejecting summonses, but they do reject summonses. I have a whole list, I have a whole document about summons practices for different.
You should share that with Ayla. Put that on the BLC website.
So, Virginia will give you as many summonses as you want. They're not too picky about how you.
Some courts will not let you have a summons for the U.S. Attorney's Office.
Right.
They say it's not a party.
Right. Some courts will only give you one summons, like often in California. And so how it works is you have to list like the named defendant, and then there's a second sheet of people to serve, and you write something like for service only, and then you list the U.S. Attorney and the Attorney General, and so you add that sheet into your summons form.
Some courts will give you a blank summons.
Yes.
And then you have to go ahead and add it in using typewriter or Adobe. It's very awkward to have a blank summons with a clerk's signature on it. You also have to know that some courts have their own, like DC, they have a summons online, a form that actually has the clerk's signature or the name of the clerk underneath the signature line. Yes. If you use a generic summons there, they will deny it.
If you're new in a jurisdiction, you have to check if they have a local summons form and a local civil cover sheet. Right.
Yeah, and in California, they have a interested parties form you have to file. There's a magistrate election form. You basically, the best practice is to go to the court website and use their forms. And I know other law firms, when I'm local counsel, they give me some template that they're using from Chicago.
Right.
I'm like, I can't do this. I end up doing the work over again.
Yeah. So there's nationwide forms put out by the Administrative Conference of U.S. Courts. You get to use those most of the time, however, not always.
Yeah, they have a nice notice of appearance form, which is nice and easy to use.
Yeah. I used to always file that, but I just stopped, and it didn't seem to make any difference.
Some courts want it, even if you filed the complaint. Other courts don't.
I haven't gotten hit with that requirement.
But when you need it, it's fast. You can fill it out in 2 minutes, and you're good.
Yeah.
But yeah, local practice is expressed through their forms, and you really need to go to their websites and see what they have there for you.
Right. So that's a little bit about the FRCP and some of the variations that you're likely to see in local rules and standing orders.
Read the local rules.
Know the rules. Yeah.
Read your judge's website page.
Read the rules up front.
Yeah, it literally will save you so much time, because fixing things afterwards with the clerk's office, it takes triple the amount of time.
And you can't bill for it. If you mess something up, you cannot bill to fix it. Right?
Yep.
All right. Great.